Stevens.
My Lord, as you know, I appear in this matter on behalf of the appellant with Mr. John Carrington of Queen's Counsel, who appeared in the courts below, and Miss Catherine Deal. And again, as you know, Mr. James Guthrie of Queen's Counsel appears for the respondent. My Lords, unless invited to outline the procedural and factual background, I don't propose to do so, assuming as I do that your Lordships are familiar with it, and it's also quite simple. My Lords will realise, therefore, that this case involves Section 2 of the Public Authorities Protection Act, and you have that at tab 2 of the Authorities Bundle at page 240. My Lords, I won't read it because you will all have read it for yourselves, but you have the reference and we'll be returning to it. It also concerns various provisions of the Public Hospital Ordinance, which you have at tab 3 of your Authorities Bundle, on section 3 in particular of which the respondent relies for the application of section 2 of the Public Authorities Protection Act. That's at page 241, my Lords, of the electronic bundle. Right. I might just ask you to turn that up because there are several provisions which it may just be worth looking at this stage. First, section 3,
yes,
which provides, in summary, for the appropriation by the government to the reception and care of sick persons of the hospital, and that the hospital shall be conducted and managed at the public expense as a hospital for the purposes aforesaid, so the reception and care of sick persons, in accordance with the provisions of this ordinance. Section 4 then provides for the appointment by the governor of a board for the proper management of the hospital and provides for its composition. I think I can then go to section 7, which is an important section, and provides that the board shall, subject to the provisions of this ordinance and all regulations made thereunder, have the entire control of the hospital, and it shall be their duty to see to the proper clothing, care and maintenance of sick persons in the hospital. The board shall have control of all subordinate officers, employees and servants at the hospital, and shall ensure that discipline and good order are maintained and that all regulations are duly observed. There is then a proviso which in summary stipulates that the medical staff will be under the guidance or direction and guidance of the superintendent of the hospital insofar as their, what I'll call, clinical duties are concerned. Section 8 then provides that the chief medical officer for the time being of the territory, which I understand to be a public service appointment, shall be the medical superintendent of the hospital and shall be responsible for the medical and surgical care and treatment of all persons admitted to the hospital. And then it may at this stage just be worth looking at section 13, which provides for board appointments, and I make it clear immediately in its common ground that the appellant was employed by the government and was not a board appointment. The board may appoint such other officers and such attendants and servants as the board may think fit for the management and service of the hospital, who shall receive such emoluments as may be determined by the governor. Such officers, attendants and servants shall be servants of the board and shall perform such duties as the board shall from time to time direct. The board, subject to approval by the governor, may dismiss such officers, attendants and servants. That provision, which deals specifically with the employment by the board of certain types of officers, does not touch in any way the employment of the appellant, who, as I say, was employed by, and it is common ground, was employed by the government and remunerated by the government as such and allocated to the People's Hospital, all of which appears from the Statement of Facts and Issues. And my Lords, by way of summary, we submit the following. First, that contrary to the finding of the Court of Appeal, and your Lordships will find it in paragraph 18 at page 141 of the electronic bundle, the government can owe private law duties to its employees which are separate from the public law duties being performed by the state. Secondly, that the Court of Appeal was likewise wrong in our respectful submission to hold, as it did in the same paragraph of the judgment, that the decisions in Vincent and the Tauranga Electric Power Board, which you have at tab 22,
Yep.
electronic bundle 567, and Duffus and the National Water Commission of Jamaica, tab 11, electronic bundle 385, established generally that an employee's claim against a public authority employer is barred if brought after 6 months.
Mm-hmm.
Thirdly, that the Public Authorities Protection Act should be construed restrictively, a consideration to which, with respect, the Court of Appeal failed to give any, or at any rate, sufficient weight, and does not extend to actions arising from breach by the government of such separate private law duties, which we submit can exist, owed to an employee. Finally, on this aspect of the matter, that the appellant was injured as a result of breach of just such separate private law duties, and her claim is not therefore caught by the 6-month limitation bar. And then, finally, but separately, because it's the other point in the case, that any public law duties owed in relation to Peebles Hospital were in any event owed by the statutory board, as the judge found, and not by the government. And my lords, in that connection, it's relevant to note that it's agreed, additionally, by the parties in the Statement of Facts and Issues, it's paragraph 2 at page 170, that Peebles Hospital is a public hospital managed by the statutory board. But my lords, that is the...
So the hospital is managed by the board. What happened was that the bed collapsed.
Yes.
So whose system was it that failed?
My lords,
I mean, I'm not averse, Mr. Stevens, to getting to the point that really matters, which is the meaning of the Public Authorities Protection Act. But why is there an action against the government in any of it?
Because the government was the employer, and because
Yes.
the government as such owed, as your lordships will know only too well, non-delegable duties, including duties to provide for...
Non-delegable, you say?
Well, my lord, yes, as a matter of common law.
see.
As a matter of common law, yes.
Right.
Non-delegable duties,
Yeah.
and that's really the crunch.
Right.
To include the provision... forgive me, my lord.
Yes, no, that's fine. That explains why you're there.
I hope that's the answer.
Yep.
So, my lord, those in summary are the 5 propositions. The first 4 go to, if you like, the bigger issue in the case. The last to what is a very short point, but actually a complete answer if it's right, namely that any public duties that were owed by the board and not by the government. My lords, I'm going to deal with matters in that way. So the first question, running together what are, I think, issues 1 and 3 in the Statement of Facts and Issues, I would put in this way. Assuming, contrary to my case, that the respondent, rather than the statutory board, was responsible for the management of and provision of services at the hospital, is the claimant's claim for damages for personal injuries sustained in the course of her employment caught by Section 2 of the Public Authorities Protection Act? So, my lords, if I can speak first to that question. As my starting point, I would make 2 related points in respect of the interpretation of Section 2 of the Public Authorities Protection Act, which I think I'll refer to simply as Section 2 from now on, if I may. First, my lords, as generally in the case of any restrictions of right, here a very significant restriction in a limitation period, and just to tell your lordships that Mr. Carrington will correct me if I'm wrong. My understanding is that the normal limitation period for an action for personal injuries in the British Virgin Islands is 4 years.
All right.
So, my lords, as I was submitting, first,
I think you're being told differently,
I'm being told 6.
right? Okay.
It gets better.
We think it's 6.
Well, I'm grateful. I got 4 from somewhere in the papers, but I'm quite happy to take 6. So, my lords,
It doesn't really matter, but
it does matter hugely.
since it may go in our judgment, we might well get it right.
Well, my lords, it matters for that reason, but it matters also simply, and it would be the case whether it was 4 or 6, that
Right.
it is a significant reduction.
Yep.
So, my lords, first, as generally in the restriction of rights, the words of the provision should be restrictively construed in my submission, having no more read into them than they expressly state or, of course, necessarily imply.
Yeah.
The second and related point is that Section 2 itself both refers to acts done in pursuance or execution of an act or ordinance and refers to any public duty or authority, and therefore expressly recognises, insofar as it specifically speaks to public duties, a distinction between public and private rights. Now, my lords, this may be a logical point to take you to the leading case of Bradford Corporation and Myers, both for support insofar as it's needed and briefly for those two propositions, but also more generally because much of my argument draws on it, and equally it's regarded as the starting point for any consideration of the relevant provision and is referred to in all the other authorities. So, my lords, you'll find it at tab 8 of the authorities bundle, 280 of the electronic bundle.
Yep.
As my lords will know, this case concerned the supply and delivery of coke, a byproduct of the production of gas, there being a public duty on the relevant authority to supply gas. And in essence, the decision came to this, that in supplying and delivering coke, the authority were performing a merely incidental function, and therefore that supply was not caught when it was tipped through the window of the claimant by the provisions of the English statute, which had the same name but was 1893.
The statutory duty was, as I understand it, to supply gas to the area. There was a statutory power to deal in the coke.
There was. My lords, I certainly don't need to take you to all of this. Can I just invite you first to page 285 in the judgment of the Lord Chancellor, Lord Buckmaster.
Yes.
About halfway down, and I'm just on the point I've made about restrictive interpretation. Words of the section themselves limit the class of action.
This is page 285?
285, my
Thank
lord.
you.
I'm sorry.
No, please. Yep.
The words of the section themselves limit the class of action and show that it was not intended to cover every act which a local authority had power to perform. In other words, it is not because the act out of which an action arises is within their power that a public authority enjoy the benefit of the statute. It is because the act is one which is either an act in the direct execution of a statute or in the discharge of a public duty or the exercise of a public authority. I regard these latter words as meaning a duty owed to all the public alike or an authority exercised impartially with regard to all the public. It assumes that there are duties and authorities which are not public, and that in the exercise or discharge of such duties or authorities this protection does not apply. And then he says that the distinction is well illustrated by the present case. My lords, just turning to page 287, electronic bundle 287,
yes.
Still in the judgment of the opinion of the Lord Chancellor, about 5 lines up from the bottom, learned judge makes the point that there is a great distinction between an incidental power to trade and a direct duty to trade, and the present case falls under the former head. And then, and it's not the only reference of this sort we'll find on the authorities, on the facing page at 288 in the second paragraph, second line, the difficulty is to draw a line between the class of cases that are within and those that are without the statute, and I'm conscious that this opinion does not establish as clear and distinct a line as I should like to see, but the statute itself is so framed that such distinction is not easy, and there may well be cases about which greater doubt may arise and more uncertainty be felt than about the present, which to my mind lies clearly outside the area of statutory protection. Lord Dunedin agreed with the Lord Chancellor. We then get the judgment of Viscount Haldane. And if I could take you to page 289, halfway down, and in particular on the restrictive interpretation point, my lords, in the case of such a restriction of ordinary rights, I think that the words used must not have more read into them than they express of necessity imply, and I do not think that they can be properly extended so as to embrace an act which is not done in direct pursuance of the provisions of the statute or in the direct execution of the duty or authority. What causes of action fall within these categories, it may be very difficult to say abstractly or exhaustively. It's hardly easier to define a priori the meaning of being done directly than it is to define the number of grains that will make a heap. But just as it's not difficult to tell when a heap is seen, so may it be easy, at least, to say of certain acts that they are not the immediate and necessary outcome of duty or authority in a particular case. My lords, I think I can then go straight to Lord Atkinson, page 290, and invite you to page 292, where about a third of the way down, he says, if the sale of coke was a reasonably good and proper way of dealing with it for this end, it might well be their duty to sell it. It did not necessarily follow, however, that they were bound to deliver what they sold at the residences of the purchasers, and above all, they were under no obligation whatever to sell to any particular individual or to any specified class or to any member of any class. And then just going to the next paragraph, for what is in my submission an important passage, excuse me, one cannot find, therefore, the obligation or duty to deliver with reasonable care for the breach of which the action is brought, except in the contract made with a particular individual, the respondent. The only duty owed by the appellants to him emerges from the contract, not from the statute. It's a duty owed to one man, not to the public. The negligence of the appellant's servants complained of was not, therefore, a neglect or default in the execution of any public duty or authority. It was a neglect or default in the discharge of a private duty to one individual and arising altogether out of that individual's contract with the public authority. Into this contract, both the parties to it were free to enter or to abstain from entering. My lords, without, I hope, doing any injustice to the opinion of Lord Atkinson, could I now invite you to move to Lord Shaw's opinion, starting at page 298, and to turn to a passage which begins at page 301, 2 paragraphs from the bottom.
Yes?
This consideration stated by Lord Kincairney, the consideration of what is the foundation of the relations of parties, forms a good key to the solution of the problem. And I will venture to add, my lords, that it will be found that the position, not of the one party, but of both parties, must rest on the same foundation. If there be a duty arising from statute or the exercise of a public function, there is a correlative right similarly arising. A municipal tramway car depends for its existence and conduct on, say, a private and many public acts, and the corporation in running it is performing a public duty. When a citizen boards such a car, in one sense he makes, by paying his fare, a contract. But the boarding of the car, the payment of the fare, and the charging of the corporation with the responsibility for safe carriage are all matter of right on the part of the passenger, a public right of carriage, which he shares with all his fellow citizens, correlative to the public duty which the corporation owes to all. Similarly, when a municipality, by virtue of private and public statutes, carries on a gas undertaking, the public duty of manufacture and supply finds its correlative in the right of the consumer, a public right which he has in common with all his fellow householders to supply and to service. In both of these cases, accordingly, the public authority's protection applies. But where the right of the individual cannot be correlated with a statutory or public duty to the individual, the foundation of the relations of parties does not lie in anything but a private bargain which it was open for either the municipality or the individual citizen, consumer or customer to enter into or to decline. And in my written case, I've suggested one could add, at least in the facts of this case, employee to that list. And an action on either side founded on the performance or non-performance of that contract is one to which the Protection Act does not apply, because the appeal which is made to a court of law does not rest on a statutory or public duty, but merely on a private and individual bargain. My Lords, that's the case of Bradford Corporation. Very briefly and additionally, in relation to the need for a restrictive interpretation, can I just take you...
I mean, just before you leave, I mean, this is obviously very important.
Yeah.
Are you saying they're all saying the same thing? It strikes me that Lord Shaw is actually being rather more specific.
Well, he is being more specific, and I rely in particular upon the correlation point which he makes.
Does one find any similar
Yes.
analysis in the other 4 or 3 speeches?
Forgive me, my Lord. Not I think, for the correlation point. However, one does find support for what Lord Shaw said in that regard in other authorities.
Not for the correlation point, but the distinction between public and private rights or duties
Yes.
certainly is,
Yes.
does appear.
Most
Certainly
definitely.
in the Lord Chancellor.
Most definitely, forgive me, I thought the question was directed specifically at correlation, but I agree with respect, my Lord.
Oh, yeah.
And how do you apply that to the present case? Just so
Well, my Lord,
clear?
Essentially, unless the private right asserted correlates with the public obligation, and in the case of somebody who boards a municipal tram...
I'm talking about the nurse.
Well, my Lord, I'm coming to that. In the case of someone who boards a municipal tram, where there is a public obligation to provide the service, and is injured, and is complaining of an injury suffered in that context, there is a clear correlation between his cause of action and the public duty. In this context, in my respectful submission, the duties, and there were several to which I will come, which were owed to Miss Alves, were purely private and do not find their counterpart, their correlative counterpart, in the public duties such as are spelt out in the Public Hospital Ordinance, and certainly not in the section 3, which Mr. Guthrie relies upon to suggest that her case is caught by section 2 of the Act.
Would that mean that if the patient suffered an injury by the collapsing of the bed, the Act might strike against
My Lord,
him, but not against the employee?
I would go so far as to submit that it might. I don't have to answer the point in this case, but I would accept that there is that distinction. And
Well, that does seem to be implicit in
yes,
what you're saying.
It is, my Lord. But, my Lord, there may be good reason why the employee who is, if you like, within the public authority and is owed specific duties, and as I'll be coming to in due course, there is a reciprocity of rights and obligations in the relationship that the employee enjoys vis-à-vis the public authority. It may be that there is good reason for giving that person the full limitation period, but the public generally a shorter limitation period.
Yes.
My Lord, that is implicit, and that certainly follows.
So you're playing both themes from the Bradford case, the public-private distinction that Lord Shaw prays in aid, but also the directness, indirectness, distinction which the other judges seem to put more emphasis on.
I am.
And you're saying this is a duty in tort which arises out of the relationship, the private law relationship of a contract of employment.
Well, yes, and the common law duties which are owed, in fact, independently of the contract, but as a result of the contractual employer.
It's a result of the status as employee.
The relationship, isn't it? Relationship.
It is the relationship, my Lord. That's exactly what I was trying to submit.
Yes.
So the patient may be caught by the limitation. The patient's visiting wife who sits on the bed, how does she come in?
Forgive me, the patient visiting...
The visitor to the
visitor
patient.
to a patient.
Yes.
The visitor to the hospital is nevertheless a member of the public, in my submission, and it would follow that potentially that claim also would be caught.
And that's the answer to Griffiths, is it?
That's the answer to what, my Lord?
To Griffiths.
It is, my Lord, and other cases like... Well, Well, but my lord, Griffiths, which...
You'll come.
I'll certainly come to it, but Griffiths, which my learned friend relies upon, is merely an example of an instance where there was a public duty, or in that case, the exercise of a public authority pursuant to a duty. The running of the school was the duty.
Person on the tram, it was like a person.
Yes, it was. But the only gloss on that, in the case of Griffiths, is that it was a sector of the public who were invited, but it was nevertheless a parent and therefore a member of the public who was invited. It wasn't an employee.
And since we've got to that case, the correlative public right which the visitor to the school had was?
Well, there was a public right. I will be coming to it, Model, but well, in fact, it might be more convenient to deal with it when I come to it, if that's all right. But there was a public right which involved the provision of the school and the management of the school.
Yes.
And as part of that,
I see.
an authority or a power was exercised to invite members of the public, a number of parents and others who were injured, to the school. And therefore there was a direct link or correlation, which in my submission doesn't exist in this case.
Okay.
Now, my lords, that was Bradford Corporation, but I said I would just briefly, I will do it briefly, refer to two other cases in relation to the restrictive interpretation that ought to be given to the statute. The first reference is the Burma Oil Company case, which you have at tab 9. Can I just, without reading the passages, give you the references? So at page 329 of the electronic bundle.
The electronic bundle is not very happily marked on the hard copy. It's
I
page
am sorry, it's
435.
internal page 435.
Page 435, yeah.
This is. I should make it clear. This is the judgment of Lord Kilbrandon in the First Division. It is followed by the judgment of the Lord President, Lord Clyde, on what was a reclaiming motion. So, first of all, 329, 2 paragraphs from the bottom. I just invite your lordships to read that to yourselves. You'll see what was said about the Public Authorities Protection Act. My lords, page 3.
Basically, so what? So
Well, my lords, what matters?
regarded. Does that
Well, no. It's the bit after that. Conceded that it is not a statute that can be applied unless the grounds for doing so are very clear.
I see. So we've had that already.
Well, you have. It's simply reinforcement.
Yeah, well, we've had
It
that.
is, and I'll simply give you for completeness the reference at 342 internally, and there's a bit more here. It's the judgment of the Lord President starting 2 lines after the second paragraph starts. The Act has always been narrowly construed by the courts since, and so on. In other words, it is the passage which Lord Nichols, in the final case I'm going to give you on this point, cites.
Right?
So
Lord-
342.
Yeah, it's internal page 448 if it's obliterated, I'm sorry. Finally, a much more recent decision at tab 12,
Yes.
Durity, where we find Lord Nichols in paragraph 20, which is at E-bundle 401,
Yep.
internal page 413, referring to what Lord Clyde had to say.
Yes.
My lords, that, and I won't say any more about it, is the obvious starting point.
Right.
It follows, my lords, that where taking a properly restrictive approach, an act is not done or neglect or default occurs not in direct execution of a statute or the discharge or execution of a public duty, the limitation provision does not apply. I then move to the next and obviously important question, and it's the question which has given the court's greatest difficulty, as we've seen from Bradford Corporation itself. It's necessary, my lords, to determine whether the relevant act was done or the neglect or default occurred in direct execution of a statute or the discharge or execution of a public duty or authority. And what the courts have struggled with, not surprisingly, is pinning that down to a single test. And it may well be that the answer is that the facts of cases in this field where statutory duties and authorities are concerned are very specific, and there is never going to be one answer. In the present case, I take as the starting point the fact that even if there was a relevant public duty on the government, as distinct from the hospital board, my second submission, to provide medical care and services at Peebles Hospital, or even, my lords, to provide nurses for that purpose, the appellant's action does not arise from and is not for any breach of that duty. The duties for breach of which the action is brought are only found in the employer-employee relationship between the appellant and the government. They are not found in any act or ordinance, nor are they public duties. Rather, returning to the point that I was asked about by my Lord Hughes, rather they are common law duties which were owed to her and her alone, not to the public more generally, and which she alone could complain were breached. In other words, my lord, and just to make this as clear as I hope I can, the claim was not grounded on the provision of hospital services to the public under the ordinance, but on the admitted provision for the appellant's use of defective plant or equipment and an unsafe system of work, as well as the further admitted failure to provide competent maintenance staff. My lords, I won't take you to the pleadings, but the statement of claim in paragraphs 6 and 7 sets out the duties. That's at pages 149 to 150 of the electronic bundle, and the defence in paragraph 1 admits every paragraph but takes the limitation point. And my lords, therein, in what I've just said, crucially lies the distinction between the appellant's action and an action brought, for example, taking Lord Shaw's example, by a member of the public injured when using transport provided by a public authority for the use of the public at large, whether in exercise of a public duty or power pursuant to a duty, or by a patient injured as a result of clinical negligence when in receipt of medical care provided by the state, again for the benefit of the public at large. So my lord put to me the question of the patient in the bed who collapses, but equally the patient who is, as a member of the public, owed a public duty in respect to the provision of care and medical services, who receives negligent clinical treatment, would, on my case, be caught by the provision, because there is a correlation.
That seemed to be the logic, and
It is.
and on that basis you distinguish the Nelson case.
I do.
Yes.
I do. Then, my lords, whilst the appellant may have been employed and was assigned to Peebles Hospital for the purpose of providing medical care to the public, that, in essence, was no more than the context in which her claim for breach of purely personal private law duties, not corresponding to or correlating to any public duty, and owed to her and her alone, arose.
In other words, you shouldn't conflate the duty to provide nurses with the duty to provide a safe system of work for nurses.
Exactly so. Because the public duty is the provision of medical services,
Including nurses.
and by extension, although the ordinance is not specific, the provision of medical staff to provide those services. My lords, another way of articulating what I've been saying, and my lords are already alive to it, and borrowing from Lord Shaw's speech in Bradford Corporation, is that in circumstances such as those out of which the appellant's claim arises, there is simply no correlation between the private rights she relied on, the safe place of work, plant and equipment, and so on, and any statutory or public duty or authority, as Lord Shaw held was necessary, and, as I mentioned, whose analysis in that regard and suggested test has been approved in subsequent authorities, including, my lords, by Lord Porter in Griffiths. Can I just show you Lord Porter? Griffiths is at tab 15, and at page 472 of the electronic bundle, at the very bottom of the page, therefore we'll be turning the page immediately. The true position is, I think, put by Lord Shaw in Bradford Corporation and Myers when he says, and then he sets out verbatim, without adding anything, exactly what Lord Shaw had to say. But not only in Griffiths, also in another case, it's the government of Malaysia and Lee Hock Ning decision, which you have at tab 14, and the specific passage in the judgment of Lord Kilbrandon delivering the judgment of the board is at 432, letter E, going over to 433 at letter D. Well, I'm certainly not going to read what was said.
Just give me those again, please. 432.
So 432 to 433. So it's 432 letter E to 433 letter D. And can I just read 433 letter D? In other words, to use Lord Shaw of Dunfermline's test, the rights of their customers were correlated with the statutory duty owed to them as members of the commercial community in whose interest the statutory functions were to be performed, not merely with obligations in a contract entered into as an auxiliary to the carrying out of those functions in which no one, not a party to that contract, could be concerned. So, my lords, I've made the point that there is no correlation between the private rights relied on in the action and any statutory or public duty or authority, because the appellant's rights to be provided with safe plant, equipment, safe system of work, breaches of which were admitted, were not public rights. There was no duty owed to the public in respect of them and no public entitlement to them.
That one's a building contract, isn't it? I mean, the dictum's helpful, but the case is about a building contract.
It is.
So it's like Sharpington.
It is, and I don't rely specifically on the contract point, and I didn't, my lord, for one moment take you to the authority for any more than
No, I understand.
the endorsement of Lord Shaw. Now, my lords, one can contrast the position of the injured patient, as my lord suggested, whose rights, when making a claim, correlate closely with the public duty owed to him for the provision of medical care, and whose claim therefore arises directly from the discharge of the public duty to provide care for him as a member of the public. I don't, my lords, really need to say any more than one can contrast it. I accept that it follows that that claim would be caught. All I really need to say is that I am not seeking to argue that anybody who suffered an injury as a result of a bed collapsing or clinical treatment, who of course have private rights, because otherwise they wouldn't have a private law claim. I'm not seeking to argue that all of those people are exempt from the provisions of the Act.
It's the correlation between the private law right, you say, and the execution of the public duty, or possibly the exercise of a statutory authority, oblique power.
Yes, and I accept that the authorities support the proposition that the exercise of a statutory authority with regard to the public can be caught by the statute.
Yes.
And in any event, such exercise of a public authority with regard to the public is almost certain to be pursuant to a statutory duty imposed on the public authority. So, and that's why the words public authority, although the notion of exercising a public authority is a slightly odd way of putting it. But that's why those words appear in the statute.
Does it equiparate public authority? Does public authority equiparate with public power?
That's my understanding.
Yes.
Yes.
Yes. And you speak about the correlation, but you could equally use the language of the other judges in Bradford and speak about directness.
Yes, I do. Now, my lord, it's right that in certain of the other cases, we'll find dicta to the effect that might suggest it's not clear what direct is meant to mean
Yes.
in those speeches. The point I make is a rather more general one. There is an obviously direct correlation in the case of the person on the bus or the patient in the hospital. There is an altogether less direct, a very indirect link between the claim of the employee.
Because of the necessary interpolation of the relationship of employer and employee to give rise to the claim. Yes.
Now, my lord,
Does that analysis work with Duffus?
well, my lord, I'm going to come to Duffus and Vincent in due course. But no, can I just, I mean, the public duty in Duffus was to provide.
Want to deal with it later.
I'm going to deal with it in terms later.
Please do. Don't let me take.
But in short, the termination of the employment in Duffus was directly in execution of the duty in that case, because it was a duty to ensure the proficient provision of whatever the service was. I think it was water. But can I come to it in due course?
No, I think that's very helpful. Thank you.
My lords, it may just be worth noting while we're on the correlation point that the Court of Appeal, in my respectful submission, wrongly conflated the distinct rights, those on the one hand of the public to the provision of medical care at the hospital and those of the appellant qua employee. My lords, just turn up page 142.
Yes.
Paragraph 19.
Yes, of course. Yep.
My lords will see in the second line at the end, the act of negligence out of which Mrs. Alves' action arose, the providing of a defective bed to a hospital patient, was an act performed by government in the direct execution of its duties to provide hospital services under the statute. Now, what they've done there, with respect, is to characterise the act of negligence out of which the claim arose, which negligence was pleaded as breaches of duties to provide safe plant equipment and so on to her, as the provision of a defective bed to a patient. Now, factually, the patient obviously was also provided with a defective bed, but the duty out of which the complaint arose was a duty to provide her with safe plant and equipment, and the breach was a failure to do that. The act of negligence was not, as the Court of Appeal put it, the providing of a defective bed to a hospital patient. And, of course, from that conflation, it was a short step to conclude, as the Court of Appeal, I respectfully submit, wrongly did, that the relevant act was performed by the government in exercise of its duty to provide hospital services.
In other words, what it failed to recognise was that the provision of a defective bed could give rise to public law duty and a private law duty.
Yes, yes.
In the same way, I suppose.
Well, that, it could give rise to a private law duty owed to the patient who would have a complaint, but it would be a separate private law duty to the very specific...
Yeah, well, we don't need to get into that.
No, we don't, my lord, but
But the point is, if it is to be characterised as a public law duty to the patient, that should not infect the quality and nature of the duty owed to the employee.
Exactly so.
That's a private law duty.
Exactly so.
And you'd say the same, would you, about defective premises? There's a hole in the floor. If the patient trips over it, he can't recover. If the nurse trips over it, she can.
Logically, yes, if I am right in saying that there is a separate duty relating to the provision of a safe place of work to the nurse, and bearing in mind the need for a restrictive interpretation.
It's very odd, isn't it?
Yeah. Okay. Now, my lords, it is also this factor the absence of the requisite, as I submit it is, requisite correlation between private rights relied on in the action and any statutory or public duty or authority which distinguishes, and I think I've really dealt with this already, the present case from cases such as Griffiths
Yes.
and Firestone, Tyre and Rubber, and I think several others. In each of those cases, if I can try and draw this together, the act complained of arose directly from the discharge of a public duty or the exercise for the benefit of the public or section of the public of a public authority or power vis-à-vis the public. So in each case, the right of the claimant correlated to a wider public duty in essence, whereas the right of the employee in a case such as the present and the right of Miss Alves does not correlate in that same way. Now, my lords, there is a...
In a sense, it's like saying a visitor to the hospital is owed simply a duty in tort, whereas an employee is owed a duty in contract and tort.
It is, but I don't invoke...
No, I know, but all I'm saying is the idea of parallel duties and
Yes.
some class of people
Indeed.
being owed a single duty and others being owed a double duty
Yes,
is not unknown to the law.
No, it's not. But it's not... I respectfully agree, but it's not the fact of the contract.
No, it doesn't go further than that.
It doesn't go further than that, my lord. Now, my lords, it's also... my lords, apart from that, there is a further important point of distinction in the case of an employee in my submission. That the private law relationship between employer and employee is characterized by freedom of choice. So neither party is bound to enter into the relationship, but once entered into, there is also a reciprocity of obligation. So the employer, for example, has to pay the employee and owes duties,
Yep.
such as those owed in this case to provide a safe place of work, system of work, safe work equipment, and so on. The employee has to work and likewise owes duties. So duty of confidentiality, a duty to take reasonable care for the safety of his fellow employees, and so on. Now that is different, entirely different in my submission, to the position of a patient at Peebles Hospital or members of the public in a case such as Griffiths, where there is entitlement on the part of the patient or visitor, on the one hand, and obligation on the part of the public authority on the other, whether arising from the existence of a public duty or the exercise of a public authority likely to be an exercise of the duty or pursuant to the duty. There is a fundamental difference. So the patient, my lords, is entitled to medical care and services merely by virtue of being a member of the public to whom the public duty is owed. The hospital or board is obliged to provide the patient and every other patient with medical care and services in accordance with the ordinance. And if the patient suffers injury in the course of being provided with that to which he's entitled by virtue of the ordinance, it comes within the protection of the Act. On the other hand, in the case of a nurse, the entitlement to be provided with a safe place and system of work and so on comes not from the ordinance, but as I've submitted, from the employment relationship, and the ordinance is merely the context in which the private obligations owed to the nurse arises. Now, my lords, that point about reciprocity is very closely connected to the point about correlation. The two, it's not the same point, but the two sit quite comfortably together, and the two distinguish between the position of the employee nurse and the other cases. And my lords, I'm going to come to those cases in a moment that the Court of Appeal relied upon, but for all those reasons, we submit, with respect, that the Court of Appeal was simply wrong, and with respect fundamentally so, to hold as they did, I quote, that there is no private duty owed by the state to a government employee which is separate from the public duties being performed by the state. Now, the two cases, the two Privy Council cases relied on by the Court of Appeal in support of that proposition, which I submit was wrong, are first Vincent and the Tauranga Electric Power Board, which was a 1937 decision from New Zealand, tab 22, 567, and second, to which I'll come first actually, Duffus and the National Water Commission, a much more recent decision from Jamaica. So if we could turn that one up first, it's tab 11 at 385. My Lords, I'm not sure I really need to take you to any passage of the case. Can I just make my submission quite shortly, because I've already effectively indicated what it is. The defendant in that case dismissed the claimant employee in order to rationalise its operations in Jamaica, and the claim was founded on the dismissal. So he alleged unlawful termination of his employment.
He alleged, did he, wrongful dismissal?
Well,
in other words, a breach of contract.
That was my understanding of it. I think the words used...
It seems to be a breach of contract.
I think it is a breach of contract claim. I think the words used are unlawful termination, but I think so, my Lord.
Yeah, thank you.
Well, I'm grateful. Paragraph 15 on page 392. The Court of Appeal dealt very shortly with this point, the cause of action for wrongful dismissal. I'm very grateful, Mr. Carrington. Now, my Lords, his claim, therefore, was founded on that dismissal, wrongful dismissal, but the dismissal by means of the abolition of his post and consequent redundancy, because that's what it was, or found to be, was held to be an action performed in execution of the defendant's statutory purposes to supervise the provision of water supply services throughout Jamaica, since the purpose was intended to improve the efficiency of the discharge by the defendant of its statutory functions. And it was in those circumstances, on those very particular facts, that Lord Scott held that any other conclusion would be astonishing. So the dismissal, the complaint, the breach alleged by Mr. Duffus was very closely connected to the statutory purpose. His dismissal was for the very purpose of rationalising and supervising the provision of water supply services throughout Jamaica.
Sorry, no, please.
It seems to be that the rationale there is, on your basis, is closer to the directness test in Bradford rather than the correlation.
I would.
Not sure correlation.
Basically, that while the claim is in contract, the destruction of the contractual relationship was the direct result of the exercise of a statutory power.
It was, and it may work better, my Lord, but I think correlation may work too. Because if there was a duty owed to the public to ensure the proficient and, what's the word I'm looking for, the proficient operation of the supply of water services, the abolition of a post to achieve that aim does correlate in that sense with the purpose. At any rate...
Not the correlation that Lord Shaw was talking about.
No,
Shaw was talking about the case where the plaintiff's
I do accept that.
right
I do accept that.
correlates with the public duty. Now, Mr. Duffus's right was a simple contractual one.
Yeah, it was. It was. No, my Lord, I'm not seeking to suggest that this is correlation in the way that Lord Shaw had it. It is much closer, and therefore the analysis may, with respect, my Lord, be that this was more obviously a direct.
The second issue actually didn't arise strictly, did it? Because the contract was terminated in accordance with its terms.
Yes, it was.
Sorry.
No, that's quite right, my Lord.
No, I mean, it does seem to me that trying to squeeze this into the correlation formula doesn't really help people because it doesn't fit. So you really have to have two tests. One is a direct test and one is a correlation test.
I do see that, my Lord. I think all I'm really submitting is that there's clearly a closer connection between seeking to run the water board rationally and sensibly and making a post which was not necessarily redundant and therefore making it more efficient and...
No one sees the directness test.
So,
One sees that.
well,
The correlation is you need to find a correlation between the rights
and
of the individual and the
If
duties.
you accept that Lord Shaw's formula of correlation doesn't work here, I think that's the end of that.
my lord, I do, and I think all I'm really saying in slightly different language is that this is closer to the directness test. Now, my lord, so far as the decision in Vincent is concerned, you've got that at tab 22.
Yes.
You've got at page 568, Regulation 178, which was the regulation on the basis of which the claim in tort and implied contract was advanced by the injured employee. And then the judgment of Lord Alness starts at 571, internal page 200. And one sees at the bottom of that page that he was a linesman in the employment of the respondents. And then turning the page, that he alleged that on 6th of June 1930, while working in the employment of the respondents on a transformer connected with high-powered lines, he met with an accident and sustained severe burning and other injuries. And dropping to the middle of the page, the crucial provision which was under consideration is set out, and that was section 127 of the Electric Power Boards Act. My lords will see that no action shall be commenced against the board or any member thereof or any other person acting under the authority or in the execution or intended execution or in pursuance of this act for any alleged irregularity or trespass or nuisance or negligence or for any act or omission whatever until the expiry of 1 month after notice, and so on. And then subparagraph 2, every action shall be commenced within 6 months next after the cause of action first arose, whether the cause of action is continuing or not. On the next page, in the third paragraph, after 3 lines, Mr. Stable, in the course of a forceful and ingenious argument, invoked the assistance which he conceived that he obtained from certain decisions pronounced in England under an analogous statute, namely the Public Authorities Protection Act 1893. In their lordships' judgment, these decisions, to say the least of it, fall to be handled with care, inasmuch as the wording of the 2 statutes differs in material particulars. And then, my lords, I think I can turn the page to the first full paragraph. Now, their lordships cannot doubt that this is an action against the board for something done or omitted to be done in the execution or intended execution of the Act. The statutory words are characterised by the utmost amplitude, and they seem to their lordships to leave the appellant no loophole of escape. It matters not whether one regards the appellant's claim as based on implied contract or on tort. The nomenclature employed appears to their lordships in the circumstances to be immaterial. The appellant, in his amended statement of claim, has chosen to christen his first cause of action as implied contract and his second as tort. Both sound in breach of Regulation 178. And then over the page, the last few lines, while not desiring to cast the slightest doubt upon the soundness of these decisions, the ones to which Mr. Stable referred, their lordships, placing the terms of section 127 of the New Zealand Act vis-à-vis of the proceedings in this case, cannot resist the conclusion that the appellant's claim is out of time. Now, my lords, the short answer to the reliance placed by the Court of Appeal on Vincent, and I don't understand Mr. Guthrie to rely on it particularly other than to refer to it in his printed case, is in my submission this. First, that the words of the statute there under consideration were materially different, significantly different to those of the Public Authorities Protection Act. And linked to that, as Lord Alness put it, the statutory words of the statute were characterised by the utmost amplitude, leaving no loophole for escape. Now, my lords, significantly, and in contrast to the Public Authorities Protection Act, the New Zealand provision that you have at 572 of the judgment admitted of no distinction at all between public and private duties. It applied to any action, and then picking up on the words of the statutory provision, against the board or any member thereof, or other person acting under the authority or in the execution or intended execution or in pursuance of the Act, for any alleged irregularity or trespass or nuisance, or negligence, or for any act or omission whatever.
So you say there's no scope for a correlation test or a directness test?
No. So, my lords, on no view of Vincent in my submission can it be said to support the Court of Appeal's conclusion that, as I've said, I've read it already, that there is no private duty owed by the state to a government employee which is separate from the public duties being performed by the state. The provision in Vincent effectively elided public and private law duties. At any rate, it didn't make any distinction between them. It could not, therefore, be relied on to support the Court of Appeal's conclusion. And what matters for the purpose of the Act with which your lordships are concerned, Public Authorities Protection Act of the British Virgin Islands, is the circumstances in which the duty is owed and the nature of the duty, and on a proper analysis of those factors in the present case, the judge was right, in my respectful submission, to find that Section 2 did not apply. And if I'm right about that, it follows also that the two local decisions referred to in the judgments below of the Court of Appeal in Bell, tab 7 at 273, and Robin, tab 6 at 266, were rightly decided, although I do not make my case by reference to the analysis contained in those judgments. But, my lords, even if you were to doubt that they were rightly decided, it affects nothing which I have said. Now, my lords, unless I can assist further in relation to the first question that I articulated, I'll move to the second question.
Thank you.
And that second question, I would, if I may, formulate in the following way.
You've dealt with Griffiths, have you?
Well, I
kept on
thought I had
promising to come back to Griffiths.
Well, I did, and then I did, but I may not have said much more than I said the first time. It was merely to make the point that it's distinguishable on the basis that there was a correlation between the right asserted by the claimant in that case and the public duty owed to the public or a sector.
You said it was, in that case, it was a section of the public. That was the point.
I did.
You said
but
that doesn't matter.
It's still a public character.
And so I didn't note it because I thought you were going to come back to it.
so
Never
sorry.
mind, if that's the point.
Yes, the invitees were a section of the public. There was no other relationship.
No other relationship, and the power exercised in that case, because it was a power or an authority, was exercised vis-à-vis the public. I think that's the way I put it, or meant to put it, my lord. I'm sorry if I didn't return to it.
Thank you.
So, my lords, the second question, if I can attempt to articulate it, it's this. Whether, if, contrary to my case, the acts and omissions on which appellant's claim was founded were performed or omitted to be performed in the execution of any public duty or authority under the Public Hospital Ordinance, such public law duties as were owed under that ordinance were in any event owed by the statutory board and not the government. Now, my lords, if contrary to my case and all the submissions I've made thus far, the matters of which the appellant complains in her action, or to found her action, fall within the remit of statutory duties addressed by the Public Hospital Ordinance, that ordinance, in my submission, placed responsibility on the board, in other words, on an entity other than the government. And if that's right, whatever public duties the respondent might otherwise have owed, none are engaged in this claim, and therefore the claim against the respondent is not caught by the Act.
Why is the government involved at all?
Why?
What's the government doing there at all? I mean,
Because it is the employer.
I know, but I mean, it's the governments don't just employ people unless they're in pursuance of public duties of some sort. That's what governments do, is public duties.
My lord, forgive me, I perhaps ought to be able to answer that. For all I know, there is a specific public duty requiring the government to employ nurses, but it's not a duty relied upon by the respondent in this case as
Well, I think
for
we've
the
got to
application of-
work, if we're trying to draw a distinction between the board and the government, we've got to work out what the government is actually doing, why it's in there at all. You can't just employ people without, other than in the context of some public duty of some kind.
Well, we do know, my lord, from section 3 itself. So at tab 3, section 3, page 241, that the buildings and so on, known as Peebles Hospital, together with all ways, paths, walls, drains, buildings, etc., shall be appropriated by the government as heretofore to the reception and care of sick persons, shall hereafter be conducted and managed at public expense, etc., in accordance with the provisions of this ordinance. Now, there's nothing at all surprising, or there would be nothing at all surprising, about that duty of appropriation being on the government, and the government being responsible for the employment of medical staff, and therefore owing duties.
Yes, as a public duty in support of its functional appropriation.
Well,
Why is that not a perfectly good public duty?
well, my lord, it might be, but the claim, the rights asserted in the claim, are not based on that. They're based on specific duties owed to the employee.
And that comes back to the first point.
Well, it does come back to the first point, but can I just seek to...
My problem is, see, I mean, I understand the first point, you distinguish between public and private, but once you get into the public duties, I do find seems very artificial to be distinguishing between what the public board is doing and what the government are doing.
Well, my lord,
They're both running the hospital.
well, they may be fulfilling separate functions which together result in the composite provision of comprehensive care for the benefit of the public at large, but there's nothing at all odd about two public authorities being involved in that way if the relevant duties in fact rest on the board and not the government. Then that would potentially be a complete answer. But my lords, this is a very short argument. Can I just develop it by reference to the provisions of the statute? Can I first?
My problem is I don't see where it's going, because it seemed to me your last answer to Lord Carnworth's question involved really falling back on the first point anyway.
Well, my lord, I thought all I was being asked was
That's
what role is fulfilled by each public authority, but I may have misunderstood the question.
I thought you said that the government is still fulfilling part of the duty of providing the hospital, and so is the board.
Well, no, I didn't say that, my lord. What I said was there would be nothing surprising if different bodies were required to discharge
Sorry,
different...
is this a pleading point, or just looking at it in the round, the government and the board are both cooperating in the provision of a hospital, as a public service.
Except they're both involved, my lord, yes.
So what's the problem, unless you're making a pleading point?
Well,
Well, your point is
my lord,
that the government appropriates, the board manages.
The board manages, and although I submit that the duties relating to management don't touch the specific and separate employment duties owed to the claimant, Mr. Guthrie relies upon the ordinance for the application of Section 2 of the Act. If, therefore, I can demonstrate that those duties were not owed by the employer, whatever those duties are, but were owed by the board, then there can be no question in an action against the government of Section 2 applying.
But forgive me, the government must be employing nurses under some kind of public authority.
Yes.
Your point, as I understand it, your correlation point is that yes, they are, but she hasn't got a public right to be employed.
They don't owe a public duty to employ her, right?
They don't owe her a public
to her,
duty to
exactly.
employ her. They owe the public generally a duty to have some nurses. That's the correlation point.
That's point one.
Quite. But given that they owe a public duty, if the correlation point fails, why is what they are doing not in discharge of their public obligation?
Well, my Lord, I hesitate from saying it is a pleading point, but...
If it is, say so.
No,
We
but,
know where we
well,
are.
my Lord, it's a bit more than that. The provision expressly relied upon by Mr. Guthrie for the provision, for the application, forgive me, of Section 2, is Section 3. Section 3 talks about the appropriation by the government of the hospital, the building and so on and so forth, and stipulates that it will be managed in accordance with the statute.
So Section 3 is relied on, but Section 3 imposes no duty on the government. That's that's it.
No relevant duty on the government. I mean, I don't accept that one gets any duties which are referable to the employment of nurses from this ordinance at all. But if Mr. Guthrie is to get home, it must be because it does employ some such duty.
Right.
Well, my lords, can we just look at the provisions of the statute? So Section 3, I'll try to summarise it and I hope get it right. Section 3 vests the buildings and appurtenances thereto, which comprise the hospital, in the government, for the statutory purpose of, and it's articulated...
So that's not all Section 3 does.
No, I'm going on, Mike. For the statutory purpose of the reception and care of sick persons. It further provides that they are, the buildings and so on, to be conducted and managed at the public expense as a hospital in accordance with the provisions of the ordinance and regulations made under it. You then go to Section 4. Section 4 provides that the governor is to appoint a board for the management of the hospital and provides for the composition of that. One then goes, as I took your lordships to this morning earlier, Section 7, which provides that subject to the provisions of the ordinance and regulations made under it, the board shall have entire control of the hospital and that it shall be the board's duty to see to the proper clothing, care and maintenance of sick persons in the hospital, and that the board shall have control of all subordinate officers, employees and servants and so on. That is subject to the proviso in relation to the direction and supervision of medical staff in the performance of their clinical duties. So, my lords, Section 13 next deals with a permissive power given to the board to appoint officers, attendants and servants if it thinks fit for the management and service of the hospital, and provides that such officers, attendants and servants shall be servants of the board and perform duties as the board directs. Now, the appellant's claim is based on the collapse of a bed as she was tending to the patient, or trying to prevent it from collapsing under the patient. Against those provisions that I've just read, the maintenance of plant and equipment such as beds was plainly responsibility of the board. Factually, under the ordinance, it was for them to do it. And there was no evidence that the board was anything other than a separate entity, which the judge found it was, nor was there any evidence that the board acted, as was suggested in one of the skeleton arguments below, as the respondent's agent. And thus, in our very short submission, on the express wording of the Act, the management and control of the hospital was vested in the board pursuant basically to Sections 4 and 7, and that can only mean that it was for the board to manage the hospital on its own behalf, and therefore there's no way of reading the ordinance so as to get from it that the maintenance of a bed was under anybody else's control.
So you say the patient would have to sue the board
Yes.
by virtue of what is said in Section
Yes.
7
Yes.
and would face the limitation.
I would.
The employee, you say, on the other hand, would have to sue her employer, the government.
Well, might be able to sue the board as well in tort, obviously.
Yes, but we could certainly sue her employer to assert the traditional duties of an employer based on what you say are non-delegable duties.
Yes.
Yes.
The action against the board, would that be subject to the limitation period?
Yes, it would.
By the nurse?
The action by the nurse against the board,
That depends on your correlation.
that depends on the correlation argument, doesn't it? Yes.
Well, this is all by way of alternative to your principle.
It is. It is.
And your point, if I can put it crudely, is that it's if the public duties are being discharged and if that has a connection with the nurse's injury, the exemption that arises under the Act applies to the board, not to the government.
I say.
Yes, I don't really understand it, but still. It may not. I mean, it seems to be unless one, the oddity may be that you should have sued the board, but the government has admitted your claim, so there we are, we're stuck with that.
Admitted the duties and the claim, but my lord, it's not necessarily odd. It just arises from the fact that there are two public authorities.
Yeah, but I mean, the difficulty is we don't really know precisely what the public duties the government is performing.
I do
It's clearly,
accept.
as my lord said, it's performing some public duty. It can't just act in the abstract.
I accept that, my lord, and perhaps we ought to have looked into that. But on the basis
That's
of
why-
the admitted facts and agreed facts, it didn't, for my purposes, seem necessary when I was considering
Might
it.
be a very artificial way of deciding this case.
Well, my lord, it is advanced as the second argument, but it is nevertheless.
Does Section 13 mean that the board could have employed the appellant in this case?
No. No, my lord.
It's not dealing with those sort of staff.
Well, doesn't
No, I mean, the ordinance in my submission doesn't touch the employer-employee relationship between the government and government-employed nurses, as this one was. It did not, for example, it doesn't anywhere, oblige the board to pay the appellant, as distinct from the position in the case of a board-appointed attendant under the very section to which my lord has just referred me, section
The
13.
board could have appointed nurses, and indeed, for all we know, might have done. And if it had, subject to the fact that the medical superintendent would would control medical activity, she would have been, wouldn't she, within section 13, a servant of the board.
Well, my lord,
That
that might depend a little on knowing more about the employment of nurses, but if one can bring a putative nurse within such other officers and attendants and servants as the board may think fit, then I respectfully agree.
Yeah.
The fact, however, remains that this nurse was employed by the hospital by the government as is agreed and was assigned to the hospital.
Understand that.
She then, for some purposes at least, comes under the control of the board, but is answerable in her clinical capacity, as are other clinicians, to the chief medical officer, who is the superintendent of the hospital and who, as I told your lordships, because this was an inquiry I thought to make, is a public service commission appointment.
But that's a professional line of...
It is a professional line of command. It wouldn't necessarily touch on disciplinary matters not related, for instance, to clinical treatment. So, my lords...
Yes, you can say you've been told it's an artificial distinction, but at the end of the day, the defence of limitation is pleaded against you based on either duties or powers arising under this Public Hospital Act. And you say that those duties and powers are not the relevant duty and power. The provision of the safe bed isn't owed to the public by the government, but by the board.
So if they do trigger the application of the Act, they were not duties owed by the government, but by the board, as my lord says. Yeah.
Yes.
My lord, that really is all the second point comes to in our respectful submission. Would your lordships just give me one moment?
Of course.
My lords, those, for the moment, unless I can assist further, are our submissions.
Thank you. It was very clear and concise. Thank you very much indeed, Mr. Stevens. Mr. Carrington.
I have nothing to add, my lords. Thank you.
Thank you very much. Mr. Guthrie.
Well, my lords, I hesitate to begin by injecting an element of muddle into the situation. But I would be anxious to avoid a conclusion based on something which doesn't represent the factual situation in the PVI. My understanding from Ms. Barry, who is over on behalf of the Attorney General's Department, is that as a matter of fact, the board has effectively no, or had at the relevant time, no part to play. Indeed, it's doubtful that there was a board as such. It was not a matter which was covered in the pleadings at all, and raised simply at the hearing at first instance. Lord, having said that, our principal submission is it makes no difference, because the public duty is plainly a public duty owed by the government. If there was a board and the board was obliged to employ nurses, as seems in fact to be envisaged by Section 13, then the government would be employing nurses effectively on the board's behalf and would be entitled to the same protection of the Public Authorities Protection Act in any event. But as I say, perhaps I can return to the second point at the end of my submissions. The overall point is the first and the main point.
But it's not clear that there was even a board in existence.
Yes, I'm afraid not. The SFI does reflect the terms of the statute. But certainly, as I read the Public Hospital Act, it does envisage, as a matter of fact, the employment of nurses by the board, which does not in fact take place, because if one fairly looks at sections 12 and 13, there's a distinction between the matron and everybody else. Everybody else presumably includes the nurses. They shall be servants of the board. But that is not the factual position. And this case has always proceeded on the basis that the government is the employer, the government owed the duties, and
notwithstanding that the governor is under an obligation under Section 4 to appoint a board, it rather appears that that may not have happened.
Well, it appears that may not have happened.
So you say that in practice it was the government which was managing the hospital?
Yes. Well, certainly, insofar as the employment of, I'm not suggesting that they took the clinical decisions, but or that there wasn't a medical superintendent.
Looking after the stability of the beds, was it?
Yes.
Well, there may have been some regulations under Regulation 15, or is that an unrealistic thought, Mr. Guthrie?
That is subject to the provisions of the ordinance, is it not?
Well, yes. Anyway.
Well, all I think I'm indicating is that it would be unfortunate if a large part of your lordship's judgment was devoted to the responsibilities of a board which was not in fact in existence at the time.
So there may be no board and no regulations under Section 15.
That's my understanding, yeah.
Okay.
But as I say, our principal submission is it wouldn't make any difference in any event, because the respondent's submission is that the government employment of the appellant was clearly within the scope of its public duty, and it can't realistically be contended otherwise. My Lords, as we're all aware, the legislation in England was not popular and was repealed in 1954, but has not been repealed in the British Virgin Islands. And underlying our submissions is the comment, I suppose, that if this is seen as unfair, then the remedy is a change of the law and not an unrealistic interpretation.
When did it first come into effect? Looking at page 240, it refers to 1916 as the initial.
Well, that is.
It was initially 1916, but seems to have been amended. Was it in 1956?
Yes, that's the only information I have, I'm afraid.
I see, but we assume that in its material particulars it was in place in 1916.
Yes, it was certainly, yes. And it is in the same terms as the 1893
Yeah.
Act.
I mean, it seems likely that the same
Yes.
More or less it is. They've actually, in copying it, left out a few words, haven't they? But,
Yes.
but can I just ask this? There's no reason why you should know, Mr. Guthrie, but those behind you might. Do we know whether a public authorities protection legislation of this kind is still in force generally in former dependencies?
It certainly is in Trinidad. Well, it was at the time of the Durity was heard.
Quite.
In a case I remember with, well, well, it was a case in which I received a fairly hostile reception from the board, and so I remember it more than some others. But I think it does feature in some other jurisdictions. It may have been repealed in some. I haven't done a comparative study.
No, but it may matter if the
Well, I can certainly
ramifications
do
of
such
the
a
decision spread more widely than
I can do such a comparative study. We also know, I think, from the materials in the bundle that it applies in Dominica
And Jamaica, Duffus as well.
and in Jamaica.
which is fairly recent.
Well,
yes.
they're fairly recent, but if it would assist your lordships, it would be a very simple matter
Probably
just to
enough.
go
Thank
through
you very much.
the different jurisdictions in the library. Well, because it's unfamiliar to lawyers practicing in England, it is perhaps helpful to look at some of the cases which were decided when the 1893 Act was alive and kicking. And I have referred to certain of those in the respondent's case, and it might be helpful just to briefly go to them, bearing in mind that in many of them, the decisions were made against the background of the Bradford Corporation and Myers case. The first case I would invite your attention to is Nelson and Cookson, which is under Divider 19 of the Authorities Bundle, decided in 1940. And just a brief introduction to the facts. An infant plaintiff was injured by the negligent treatment of assistant medical staff at a hospital run by the local county council. And it was found that the defendants were performing a public duty on the council's behalf and were performing a duty that the authority could only perform through other persons. So that the English Act of 1983, and this is one example of a situation in which it plainly did not affect the result that the persons performing the duty were only, so to speak, indirectly within the scope of the duty and not the persons on whom the duty was directly made. But can I, before going to the judgment, ask your lordships to note at page 530 that the case of Bradford Corporation and Myers was raised in argument,
Yes.
and then take you to page 532, the judgment of Mr. Justice Atkinson, about 5 lines down. These two defendants, in other words, those administering the medical treatment, were exercising what was really a public authority, because it was an authority given to the Middlesex County Council to provide and maintain this hospital. The council could not exercise that authority by their own hands, but must act through other people. And on the relevant occasion, their authority was being exercised by these two medical men. It seems to me idle to say that they were not acting in pursuance of a public duty and authority conferred on the Middlesex County Council. They were performing this public duty or authority, whatever you may like to call it, as agents or delegates for and behalf of the council, and they're entitled to the benefit of the Act of 1893. And that goes in, if you like, to my learned friend's second point. It's idle to pretend that someone who is employing a nurse as part of the management of a hospital, even if that management is conferred on a board, is not themselves acting within the scope of the duty, which is to manage the hospital.
But in that case, the point being taken by the unsuccessful claimant was that because there was a separate duty, as it were, on the doctor, that made a difference. If one looks at the argument on page 529, Mr. Noakes' argument.
Yes.
It was a narrow point, and one could see the pithy reply given by counsel for the hospital over the page. So the judgment was based on a point that's rather different from the one being argued here.
Well, the plaintiff was injured by negligent medical treatment, and that was held to be within the scope of the duty to manage the hospital. And it's simply an example of the wide scope of the Public Authorities Protection Act as it was applied in the United Kingdom when the Act was in force. But I can go on to the second case, which is Higgins, and which is at Divider 16. The facts of that case, it was a part-time specialist who was alleged to have treated a patient negligently. And the judgment of Mr. Justice Pilcher at the page E481, the second paragraph on page, not really.
Which page, Mr. Guthrie?
481, my lord.
481, thank you.
It was not really in dispute that even giving to Mrs. Higgins the injection which he did, Dr. Batch was acting in the ordinary course of his duty as a part-time specialist under the National Health Service Act in charge of the physical medicine department of the Mount Vernon Hospital. For the purposes of this case, I assume that the duty of treating patients within the region which they administer, as well as the duty of administering the health service provided under the Act, was upon the hospital board, which was itself a public authority and entitled to the protection of Section 21. If Dr. Buck, who was a part-time specialist, can properly be regarded as a servant of the hospital board, and if he was at the material time performing or purporting to perform as the servant of the board of public duty laid upon the hospital, it's not in dispute that he is entitled to the protection of Section 21, Section 1. The reference to Bradford and Myers is at the top of the next page at E482, but I should begin at the bottom of 481. The argument presented on behalf of Dr. Batch ran along these lines. In giving the treatment which he did, Dr. Batch was performing on behalf of the hospital board one of the very duties which had been directed to perform by the minister. This duty was a public duty, and one which the board, on the assumption the duty had been properly delegated to them, could only properly perform by the hand of an experienced doctor. Dr. Batch, in giving the treatment in question, was in no sense performing an act collateral to the duty of the board, as was the case in Bradford Corporation and Myers. And we, of course, say in this case that the employment of the nurse is in no way a public duty somehow, or some way an act collateral to the public duty to manage a hospital, but indeed an essential part of that duty, a hospital.
Well, the analogy would be apt if it was the negligence of the nurse that had caused the damage. But here, what Mr. Stevens says is the critical distinction is that this is not the discharge of a public duty on the part of either the board or the government. It is a private law duty owed to the nurse.
Well, one might say the same thing about the operation on a patient. It is not the error which is carried out by the doctor is not a part of the duty. But if one cannot, in our respectful submission, suggest that the employment of a nurse does not bring with it all the ordinary obligations of an employment contract. We simply reject the idea that one can artificially suggest that the duties which arise in the course of a contract of employment for these purposes can somehow be divorced from the duty to employ the nurse. They are part of the duty to employ the nurse. The duty is to employ a nurse with all the attendant obligations that a contract of employment.
I think Lord Shaw's analysis would say there's a difference between, for instance, contract with a member of the public who goes on the bus and a contract with the bus driver.
Well, we consider that
I think
that distinction is, if you like, entirely based on the factual circumstances which confronted Lord Shaw in the Bradford Corporation and Myers case.
would you accept that if one had that sort of contract, that the contract with the bus driver would be subject to the 6-month limitation if one assumes that the contract was one in principle, or the body, the employer was within the ambit of the statute?
Well, the situation is so different with respect. I'm not sure I should, so to speak, offer any hostages to fortune by accepting that.
No, fair enough.
But the third of the initial cases illustrating the operation of the Act in England, which I was to take you to, was the case of Razzle and Snowball.
So we've had two first instance cases, and now we've got the Court of Appeal.
Yes, this is the Court of Appeal.
Yes.
Well, my Lord, they are referred to by the Court of Appeal in due course.
Perfectly fair. Thank you.
Where are we going now?
Tab 20.
Tab 21.
Tab 21.
Yeah.
This is a case in which the relevant duty was to provide the services of specialists. The defendant
I see the introduction at the beginning of Lord Justice Denning's judgment is unusually explicit, the first two lines.
Yes.
A judgment which he later revised to read as follows.
Well, I have to accept, but I know your lordships will not regard it as decisive, that the judges have had very little good to say, if anything good to say, about the Act. I have come across two references, which I'll come to when we look at the cases themselves, which give some explanation of the legislative purpose behind the Public Authorities Protection Act. One, indeed, in the course of the judgment of Lord Shaw, which you've looked at already. But,
anyway, I'm sorry, we were going to take us to
yes,
the...
I don't
you
think I have...
You can tell us the facts. I'm very sorry I interrupted.
No, it does, that passage does underline the point that I make, because whether one likes the law or not, the judges in the British Virgin Islands are obliged to follow it. I was going to take you, in this case, to Lord Justice Morris,
right.
E565.
Thank you.
The first paragraph of his, it was the duty of the minister to promote a comprehensive health service. In the course of performing that service, it was his function to provide hospital and specialist services, as well as hospital accommodation. It was therefore his duty to provide the services of medical men in the hospital, the service of nurses, the services of the hospital staff, and also the services of specialists. And then, if one drops down the page, about 8 lines up from the bottom, it seems to me idle to say that they were not acting in pursuance of a public duty. This is a reference from Nelson and Cookson. And similarly, in this case, it can be said that Mr. Snowball was doing what he did as the agent or delegate for or on behalf of the minister. Now, in the present case, of course, the nurse was directly performing nursing services when she was unfortunately injured.
And Lord Justice Denning also, it's fair to say, cites Nelson and Higgins with approval.
Yeah, both Nelson and Higgins cite Bradford Corporation and Myers.
Yes.
And we submit that the facts of that case are not easily translatable to a situation in a public hospital or the activities of a nurse. In that case, your lordships have already seen it, the public duty concerned was to supply gas, the sale of coke produced in the manufacturing process was not done in the discharge of that duty at all, but was, and Lord Shaw, it's at page 264, my lords, referred to it as being a private and individual bargain.
Well, they had a statutory power to enter those private and individual bargains, and that statutory power, the 1893 Act potentially covered, because it speaks about statutory duty and also statutory authority. But the House of Lords chose to limit the application of the Act by looking to the private bargain that was entered into in the exercise of that power.
Yeah, but the points which were made, so to speak, as were made as to reciprocity and correlation are made in the context of a private bargain, which was wholly outside the scope of the duty which was upon the corporation to supply gas.
Well, it was outside the scope of the duty, yes, but it was firmly within the statutory power to sell the coke. That's the problem.
Yes. Well, but the reason that it was not caught by the Act was because it was outside the scope of the duty.
Well, right.
And we saw that that was what I think Mr. Justice Atkinson, or Mr. Justice Atkinson said about it in Nelson and Cookson. It was in no way, it was in Higgins, I'm sorry.
It was Higgins.
Yes.
Was Justice Pilcher.
Yes, Mr. Justice Pilcher, yes. It was he distinguished what the doctor was doing as being in no way collateral to the duty of the board, as the provision of coke was collateral to the duty of the corporation in Bradford Corporation and Myers.
See, the public duty in Higgins and Nelson was to ensure that efficient medical staff were provided in order to discharge the public obligation of the health authority to the patient. And here, the public duty that arises is to ensure that nursing staff, including Mrs. Alves, were effective and efficient nurses.
Well, with respect...
But I'm sorry, just let me finish. But the point is that the duty owed to Mrs. Alves and an employee is at best ancillary to the public duty or incidental to the public duty.
Well, it is surely a necessary part of the public duty to employ nurses. It cannot be simply hived off and for the purposes of distinguishing whether it's a public duty or not a public duty. The public duty was to employ nurses such as Mrs. Alves, and that is what was done. And it was in the intended execution of that public duty that she came to be injured through an unsafe system of work. And it is unrealistic, in our respectful submission, to draw these distinctions.
You say that, but look at what, since Lord Atkinson says, Lord Shaw is, in a sense, the high point of the case against you, so far as Bradford's concerned. But what about Lord Atkinson on page 292? No obligation whatever to sell to any particular individual or any specified class, and so on. And what might be said against you is, yes, they've got a duty to run a hospital. They don't have any duty, they never have had any duty to Mrs. Alves to employ her.
Well, once they have a duty to employ nurses.
Yes.
And that encompasses the employment of Mrs. Alves. Oh, that is the way in which we put it.
Yes, I see.
And my lord, the case is time and time.
They say if the sale of coke, according to Lord Atkinson, if the sale of coke was reasonably good and proper way of dealing with it, might well be their duty to sell it. So if employing nurses was a good way of running a hospital, which on the face of it pretty clearly is, it's a good way of doing it. But it doesn't necessarily follow. And then what follows in that may be said to be rather against you.
Well,
they weren't obliged to employ her.
If one applies the analogy and says that if it had been within the duty, or if it had been a reasonable part of the duty to sell the coke, then the claim would not would have the limitation defence would have succeeded. So it being reasonable to employ Mrs. Alves, she falls within the protection of the Act.
I would partly a difference between selling coke may be a very good way of carrying on their business or carrying out their duty, but employing nurses is an inevitable part of running.
Exactly. Well, I mean, it is an absolute
sine qua non.
It's quite impossible to run to construe the public duty as not including the duty to employ nurses. But if and we go further and say, well, if that is the duty, then it is plainly caught by the words of the Act. We entirely accept that the authorities require the Act to be strictly construed, but it can't be cut down beyond the plain meaning of the words which it contains. And if the employment of Mrs. Alves was a part of the public duty, then that, with respect, as identified by the Court of Appeal, is the principal question in the case, and it should be decided in the respondent's favour. But I also would ask you to bear in mind that all of these cases contain the warning that they may not be of general application. And that is particularly the case, we would submit, of Bradford and Myers, on which the facts would really hardly be more different. And it would be very dangerous to extract from Lord Shaw's observations when he's referring to a private contract for the supply of coke, a principle which can be applied in vastly different circumstances. And indeed, the effect of Bradford and Myers, at least, was substantially cut down, or explained, I should say, in the Griffiths and Smith Authority.
Which, as Lord Conworth said, we haven't looked at in any detail.
We haven't looked at in any detail yet. Just before leaving Bradford and Myers, I did refer to the remarks of Lord Shaw, so to speak, explaining the legislative purpose of the section.
You did, yes.
They are to be found at E298.
Thank you.
In which he says, the limitation prevents belated and in many cases unfounded actions. In this way, it pro tanto allows a safer periodical budget, prevents one generation of ratepayers from being saddled with the obligations of another, and secures steadiness in municipal and local accounting. Well, one has to remember that the BVI is a comparatively small jurisdiction, and no doubt there are advantages in being able to.
That's right. Is that a similar consideration to what underlies the present rules in public law in this country about the necessity for claims for judicial review to be brought within 3 months and indeed promptly?
Well,
it's the same argument, isn't it?
It might include that argument. I don't think it's probably a wider argument.
Well, it's a
wider argument of good administration and policy making.
Yes, and in fact.
But well, how does it? If that's the rationale, how does the provision of a safe system of work to your employees fit within it?
It's not the provision of the safe system of work. It's the good administration, the bringing of actions, and knowing where the government stands.
Quite.
Yeah. But I don't think I need I need actually rely on this. I don't rely on this in any way.
All you're saying is that other judgments diss it, so at least this title to refer to.
Well, since we're now on Griffiths and Smith under divider 15, you might be interested to see what Lord Wright said about that in E452.
Just before we go there, if Lord Shaw's rationale for the section is, for the provision is correct, Is there a case law in the United Kingdom of it being applied, for example, to road traffic accidents? Do you know?
I haven't come across it, but it's not in any of the cases that I... unfortunately, it's been necessary for us to...
The tramway ones are the nearest,
Yeah.
to it, aren't they? And they're passengers on the tramway. But what about the chap into whose carriage the tram runs?
That's precisely what I was thinking about.
Yeah. Well, I suppose, well, the ambulance driver who runs over a pedestrian.
Absolutely.
Yeah.
Yes,
Yeah.
exactly.
Yeah. Well, no doubt these considerations may well have contributed to the judicial dislike of the effects of the statute.
It might be quite interesting to know whether insurance companies ever... Oh, of course, they wouldn't have been insured.
No, they wouldn't have been insured, no.
Oh, well, they might have been
Yeah, they might have.
by the 1930s. They probably would have been. It'd be interesting to know whether insurance companies ever took this point in a road traffic kind of situation. Anyway, there we are.
You were going to go to Griffiths.
Well, I was just going to as a sort of preliminary to Griffiths, Lord Wright, I think, was accurate at E452 when he says, at the foot of the page, it's impossible not to sympathise with persons who have suffered a grave wrong, find their claims defeated in this way. But a definite periods of limitation may often involve a serious prejudice in particular cases. All that can be said is that the legislator has fixed the precise period, no doubt, for what has seemed to it good reasons. Well, that's
Not exactly an enthusiastic endorsement.
But it isn't. but that is that, so far as we're concerned. I mean, that
It really
is...
does look as if it's an administration point, doesn't it?
Yeah.
It's the same as the public law
Yeah.
provisions
yes.
still exist.
And no doubt that
Yes.
That's what it's all about.
one might say that the so to speak, the financial aspects of the administration point may weigh more heavily in a small place than a large place.
Yes.
Yes, thank you.
But you'll recall that the context of Griffiths and Smith was an injury caused by an unsafe structure at an elementary school which was managed by the defendants under the 1921 Education Act, and the occasion was an exhibition of pupils' work. And parents and family and interested persons were invited to go and see what the children had done. The first passage is in the judgment of Viscount Simon, page 440. He begins the scope of application about a third of the way down the page. The scope of application of the Public Authorities Protection Act has been the subject of many decisions, and the question was considered by your Lordship's House in Bradford Corporation and Myers, where some of the earlier cases were in effect approved. I've had the advantage of reading the opinion about to be delivered by Lord Maugham, glad to adopt his review of the previous decisions. Lord Haldane's speech in the Bradford Corporation case contained a warning that it might be difficult to extract a comprehensive principle, and then quotes from the case. One difficulty in determining the exact scope of the Act has arisen from the circumstance that its first and main section is so widely drawn as to suggest that the protection which it affords is available to any person for any act done by him in intended execution of any Act of Parliament. There is, however, a considerable body of case law to the effect that it does not apply to protect defendants who are not in some sense public authorities. And this view is affirmed by Lord Buckmaster, and you've seen his case. There is, however, a second question connected with the construction of the Act on which it is difficult to reach precision. Assuming that the person is a public authority in the sense required, what kind of action by the public authority is to be regarded as satisfying the conditions of the section that the Act must be done in pursuance or execution or attended execution of any Act of Parliament or of any public duty of authority, or that the neglect or default must be in the execution of any such act, duty, or authority. In one sense, everything that is done by a public authority within the limits of their statutory powers might be regarded as done in execution of the statute. Even if a public corporation exists independently of statute, all their actions within their powers might perhaps be regarded as done in execution of their public authority. But this House has decided in Bradford Corporation the statute ought not to be given so wide a construction. It is not because the act out of which an action arises is within their power that a public authority enjoys the benefit of the statute. It is because the act is one which is either an act in the direct execution of a statute or in the discharge of a public duty or the exercise of a public authority. Then the facts of Bradford Corporation. There are thus two questions, reading from the middle of 442, to be decided as to the application of the Act in the present case. First, are the managers a public authority? Secondly, was the neglect or default proved against them, neglect or default in the execution of their statutory duty or authority? In my opinion, both these questions should be answered in the affirmative. I can go over the page. Lastly, was the action of the managers in authorizing the invitations to this school display an act done in the execution of their statutory duty or authority? It was strenuously contended for the appellants that this action was voluntary, in the sense of which the sale of coke in the Bradford Corporation case was voluntary. It is true that St. Clement's School could have been carried on without arranging to hold this display, but that is not the true test. The real question is whether the managers, in authorizing the issue of invitations to the display on the school premises after school hours, should be regarded as exercising their function of managing the school. To apply the distinction indicated by the Master of the Rolls, was the manager's action something incidental to part of the process of carrying on their statutory duty? Both the trial judge and the Court of Appeal took the view that in this matter the managers were doing an act which formed part of the operation of carrying on a public elementary school. Then refers to the Master of the Rolls and Mr. Justice Tucker. The last sentence of which is, I am further of the opinion that on the occasion in question, the school was being used as a public elementary school and not for some extraneous purpose unconnected with its functions as a school. I entirely agree with this view, which has prevailed in both courts below. It would be within the discretion of the managers to decide whether they would approve such a display or whether they would not. The point is that they did approve it, and that they did so in the course of carrying on the public elementary school and of exercising the powers of management conferred upon them by the Education Act. There is, in my opinion, no ground whatever for saying that the invitations issued to this display were issued for some extraneous purpose unconnected with the management of the school.
If you applied that test to Bradford, you'd reach a different decision.
Yes.
What Viscount Salmon says on page 443 and 444 it seems to me to be a perfectly reasonable way of approaching matters, but totally inconsistent with Bradford.
Well, be that as it may,
Dealing with the argument which was presented to him, which was this is a voluntary activity outside running a school. It's as if we'd allowed it to be used for a polling station or something like that.
Purely private.
Or for the village, for the village dramatic society to meet there or something like that.
But it is interesting to note that what was being concentrated on was the invitation to the public. It's not... I would say that the equivalent stage one's looking at in the present case is the employment of the nurse. And it is not concentrating on what went wrong with the structure of the school.
Right, I'd have thought what it's concentrating is the provision of the service. I mean, you might say here the provision of the service is providing a bed, which is clearly, and if the bed collapses, then that's whoever gets injured by it, that's part of the function
Well, in this case, then, the provision of the service would be provision of the building where the exhibition was taking place, where the children's pictures were being shown. We say that what one has to look at as being the operative part of the public duty is the employment of the nurse. But perhaps I should go on with what was said by Lord Malm at E449, I think. It's a third of the way down. He said, "My Lords, since the decision of this House in the Bradford Corporation case and the tacit or express approval of the cases I have referred to, it has been impossible to doubt, if it was doubtful before, that it is not essential that a public authority seeking to rely on the Act of 1893 must show that the particular act or default in question was done or committed in discharge or attempted discharge of a positive duty imposed on the public authority. It is sufficient to establish that the act was in substance done in the course of exercising for the benefit of the public an authority of a power conferred on the public authority, not being a mere incidental power, such as a power to carry on a trade. The words in the section are public duty or authority, and the latter word must be taken to have its ordinary meaning of legal power or right, and does not imply a positive obligation."
How does that work with Bradford, though? It mentions Bradford, but how does it work, if that's right?
Well, Lord, it's a later decision of the House of Lords.
Well, it was certainly, at the very least, a revision of Bradford.
Well, it has been.
Bradford revisited, yeah.
Yes,
The
not a complete
but
rejection of it.
the words which we consider with respect are important. It's not essential that an authority seeking to rely on the Act must show that the Act of must show that the particular act or default was done or committed in discharge or attempted discharge of a positive.
Well, again, Mr. Guthrie, if you look back at 435, you can see why he expresses himself in those terms, because he's addressing the argument which was put. They didn't call on the defendants, but the argument for the plaintiffs was bottom of 435, top of 436. The appellant's right to be present was solely by reason of a purely private arrangement. Another case called Greenwood, where the playground, which depended on providing a playground, if it held, to the extent that it held that providing the playground was in pursuance of a statutory duty, was wrong, and the use to which the building was put was at the most permitted and was purely ancillary. So the argument was it's ancillary, it's voluntary. And that explains, doesn't it, the terms in which Viscount Malm expresses himself on 449.
Where he says it is sufficient to establish that the act was in substance done in the course of exercising for the benefit an authority or a power conferred on the public authority.
Yes.
Surely that is apt in the present case, because the complaint is that the collapse of the bed is something which was part of an unsafe system of work or the way in which it's put. And surely that is something which can be regarded as being an incident in the course of the employment of the nurse, which it was the government's public duty to provide.
Yeah.
And we say there's no getting away from that. If the government can establish that the provision of the nurse's services was a necessary part of its public duty, then it was a direct exercise of its public duty. And that is the end of the case, because it was in the intended, in the pursuance or intended pursuance of that public duty that the nurse was injured, and in respect to which she brings her claim.
As a matter of interest, if you go on to 451, you've got a running down case. Edwards.
Yes. It's quite interesting.
Yes. Well, that's perhaps an example of the difficulty one can get into, in that Lord Justice Younger said it would have been decided one way if it was the outward journey and the other way if it was coming back.
Yes.
I have the impression that Lord Morne thinks the majority were right on that case.
Yes.
And that it's really what you're looking at is the act, whether the act of taking out your casks to the central depot is part of your performing your duty, and if it is, then that's protected, and they're not too worried about who you knock down. That person has to put up with the limitation.
But that is exactly the present case, because the employment of the nurse.
But here it's nor the act, the relevant act is providing the bed which then collapses.
Well, the way in which it's put is that is part of the safe system of work for the nurse. I mean, the duty to provide the safe bed might be considered to be certainly a public duty and aid to everybody, because any old patient might find themselves in the bed.
It all depends on the correlation point, doesn't it, Mr. Guthrie? The bed is provided out of the duty to the patient, but it's not provided out of the duty to the nurse. Not a public duty, anyway.
Well, I'm not sure that that's right, my lord, because it is provided as part of the duty to the nurse.
Because she's part of the population.
But, well, that, and because she, in the exercise of her duties as a nurse, can reasonably be foreseen as coming into contact with beds and patients.
I mean, the correlation point doesn't come into Edwards at all, does it? I mean, there's no question of the plaintiff having any correlative rights or duties with respect to the plaintiff is just someone who happens to be on the road and is knocked over.
Yeah, well, that's why I asked about were there RTA cases, because the correlation test didn't seem to apply in that context.
Well,
Edwards is right, the correlation point doesn't really come into it.
Well, in our respectful submission, it is a red herring. It obviously comes in, it's a perfectly reasonable comment to make on the facts of Bradford Corporation, but it is only a comment on the facts of Bradford Corporation. It's not a matter of general principle which can apply to. I mean, it can't be read into the words of the Public Authorities Protection Act. Well, there are some additional cases which consider Griffiths. It may be just worth mentioning that in the Western Indian Match Company against Locke case, which is at Divide 23, the decision of the Lord Chief Justice Goddard, he regarded Lord Morne as having solved any difficulty which had been caused by Bradford Corporation and Myers. It's on page E581. It's beyond question the Crown is a public authority. Whether the public authority is protected depends on whether the act complained of arose out of the discharge of a public duty or the exercise of a public authority. See Bradford. I don't find it necessary to quote from the speeches of the noble lords in that case, because although Lord Haldane pointed out that it may be difficult to extract from the words of the Act a comprehensive principle which would serve as a guide for the future, in Griffiths and Smith, Lord Morne has summarised the effect of that case and those which have preceded it in a passage which I venture to think goes far to solve any difficulty. And then he quotes the passage which your lordships have already seen. Lord, there is some further assistance in the cases as to what falls within and what falls without the scope of a public duty. We have the Government of Malaysia, Lee Hock Ning Privy Council case at Divider 14, which you've, I think, briefly been referred to by my learned friend. This was a building contract case, as you remember, and the judgment is Lord Kilbrandon, 431 E, letter H, beginning there. It refers to two cases which I'll take you to in a moment, McManus and Bowes, Thompson and West Ham County Borough Council. A claim for a salary by a relieving officer was held protected. In both these cases, the default lay in failing to carry out the duties which had been laid upon the authority and were therefore clearly committed in the execution of that duty. In Mountain, the statute, I think I can move forward to letter B on the next page. So also in Bradford Corporation and Myers, the contract which the authority made with the plaintiff, although ultra vires and made in relation to the statutory powers of supplying gas, was a private contract, inasmuch as the making of it was not a statutory function of the authority, but subsidiary or ancillary to the carrying out of those functions. And letter D to E, the point was put rather differently by Lord Shaw of Dunfermline. And I think this is the passage which my learned friend took you to this morning.
I must say I struggle with the idea of the contract being ancillary. I mean, it seems to me if you're given a power to trade and you do trade, I don't see how you can explain away Bradford by words such as incidental or ancillary.
Well,
you see, if the Morm test were to be a universal test, this case would be within the statute, wouldn't it?
well,
The building contract is entered into in exercise of the public function, authority or power to provide schools. It's a contract to build a school, I think.
well, the contract, the private contract to build a school, may be said to have nothing to do with the purpose of the statute to provide education.
Surely just as much as you said you obviously need nurses if you're going to provide a hospital, you obviously need a school if you're going to provide education. What's the difference?
Yes. Well, I see that put like that, that's correct.
It happened, you see, in Sharpington earlier, which is the poorhouse case. The poor law authorities, their only function, or their principal function anyway, was to provide suitable accommodation, and they enter into a building contract with the builder to provide it. That's not caught by the statute. Now, if the Morm test of discharge or attempted discharge of the statutory function is all that you need, why are these contract cases failing? Not failing?
Well, I think it's the point my Lord Hodge says he has found difficulty with it. They say that they're incidental or collateral. Whereas in our respectful submission, the employment of the nurse is certainly not describable as either incidental or collateral. Thank you. But
Yeah, okay.
I was going to take you to the two cases referred to, McManus and Bowes, which you'll find at Divider 18.
Where do we look here?
This is perhaps
We got it, 18, 495, yeah.
Divider 18 is a 495.
Yeah.
Just for the facts, you'll see that a doctor was dismissed.
Yes.
He brought an action for wrongful dismissal, and that claim was barred by the Public Authorities Protection Act. The short passage that I've marked is at E521 in the judgment of Lord Justice Slessor.
Yep.
First, to the second point, this is at the foot of the page. I think it is necessarily involved in the decision. The first point, had Dr. McManus in fact been employed under a contract of the kind which has been discussed in some of the cases dealing with the protection of a public authority, such as Bradford Corporation and Myers, it would have followed, I think, that the local authority could not have invoked the protection of the statute against him. As Lord Buckmaster said in that case, in other words, if I just after the quotation marks, if the only connection between the employment of Dr. McManus and the statute had been that the local authority would have had to point to the statute as an enabling statute to give them power to make contracts with doctors on such terms as they thought fit, then I think that it might be argued, this being an act which is not only within their power, but in which they are free to make such contracts as they think fit, the case would be like the sale of coal products, and the Public Authorities Protection Act would not apply.
Yes, I see.
Similarly, in Sharpington, where a local authority had power to build houses for the reception of the destitute, it was held that a building contract made under that power was not in itself an act done in pursuance or execution or intended execution of an act of Parliament, and that the act did not apply. If the true view be that this appointment and removal are directly statutory, not by reason of any contract, but by reason of the operative language of the section itself, as I think is the case with such an office as this, where the office holds office during pleasure, then I think it follows that such a case is not a contract of the voluntary nature suggested, or in several cases which are there discussed, but is a direct execution of the statute itself.
Yeah.
That is what we say is the position here, that the employment of the nurse is in direct execution of the statute itself.
Thank you.
And then the last of these particular cases, Compton and West Ham Borough Council,
Yep.
which is at divider 10, E476.
If your case is to be pinned on the employment of a nurse being a direct execution of a statute, it would help me to know what statute.
Well, it is the directly involved in the management of the hospital, which is under Section 3 of the Public Hospital Ordinance.
That's the only provision you can
well, we rely on that,
as...
but yes, I've faced...
So you're pinning that on Section 3?
Well, the case has always been run on the basis that as a result of the establishment of the People's Hospital, the employment by the government of nurses is a necessary part of the public duty to run the hospital. And it is not in any sense ancillary or incidental to that. It is direct execution.
I see.
We go to electronic 376, tab 10.
Yes. The
Decision of much loved Mr. Justice Crossman.
The facts in that case, the employee was a relieving officer under the Poor Laws, and the operative part of the judgment begins at E382.
Yeah. Yes, well, he takes the point, at the bottom.
And counsel for the plaintiff, these last lines of the page, the Act does not apply because the action is for breach of contract, relies on various cases. Then there's a quotation from
Holsbury's Laws.
Holsbury's Laws, and the point is made in that case that the appointment of the plaintiff was an appointment which the defendant counsel was bound to make under the Act. And it's our respectful submission that the employment of the nurse, Ms. Alves in the present case, was something which was an inevitable and necessary part of the duty.
Very well.
On the thing. My Lords, I was going to consider the local cases briefly, which were relied on by the judge and which the Court of Appeal distinguished. It would not be a long exercise. The first of them is Bell, which is at tab 7, which is the case about the police officer. He was injured in the course of firearms training, and the judge found at paragraph 13 that this is the Court of Appeal reversing the judge at first instance. the judges posing the question is paragraph 12, and the judge in the Court of Appeal, Mr. Justice Redhead, says that the question posed is premised on the wrong factual basis. By requiring the plaintiff to attend and participate in a firearms training exercise, the defendant was performing an act in pursuance or execution or intended execution of the duties imposed by the Police Act. And the respondent denied that that was the case. And then the paragraphs 24 and 25 suggested that statutory duty could not have included requiring the police. So it's basically decided on the Bradford and Myers point. And indeed, none of the other cases, such as Griffiths and Smith, are mentioned.
Yes.
The same is true in the second of the local cases, Loretta Frett, which is under Divider 17.
Thank you.
I hardly need, I think, didn't trouble you at any length with this, but it was a decision of the master at first instance, but was again referred only to the Bradford and Corporation case. It was a case of mesothelioma, in which the claim was damages caused by asbestos particle released during the construction.
But basically, it's in the last sentence of paragraph 10 on page 493.
It is.
Isn't it? No public duty imposed on the minister by the Act to demolish walls, cut holes. Yep.
But the third of the cases, which is the Dominican case, was a case which did involve a nurse who was injured by an electric shock at the hospital where she worked. The auditors will find that under Divider 6.
Thank you.
What is quite interesting, my lord, is that it was a decision given by a single justice of appeal, because it was an interlocutory appeal, and the rules in the Eastern Caribbean allow those appeals to be heard by a single Lord Justice. The single Lord Justice in question, or I should say Justice of Appeal in question, is actually the same judge who delivered the judgment in our favour in the Court of Appeal in the present case. So he reached a different conclusion in Miss Alves' case as he did in Miss Robbins' case. It's not a very satisfactory report because the head note does not seem accurately to reflect the reasons which come later in the judgment. The second paragraph of the head note on page 267 reads, "The limitation defence under the Act would only be available where the Act is either an act in the direct execution of a statute or in the discharge of a public duty or the exercise of a public authority. The act of renovating the dialysis unit was not such an act. As such, the limitation period of 6 months stipulated under the Act is inapplicable to the respondent's claim." And I couldn't see in reading the judgment that that did form part of the reasons why the...
Well, the reason really is in paragraph 10, isn't it?
It's all in paragraph 10.
Really,
you'll have perhaps picked up from our written case that we somewhat criticise the reasoning there.
You say he wasn't referred to all the relevant authorities.
Well, he wasn't. In fact, my learned friends have pointed out that it would have been very difficult for him to be referred to one of them because it hadn't yet been decided. But apart from that, not only that, but the reasoning, that is because the act complained of in our case arose allegedly in the execution of a private obligation which the hospital authorities owed to Miss Robin. The act complained of in this case arose because allegedly a contractor employed to do renovation work did so carelessly. It is not because the act complained of is one which is within their power that a public authority enjoys the benefit of the statute, unlike the duty which the hospital authority may owe to its patients. The duty which it owes to its employees is owed to the employees personally. No member of the public could complain if the authority did not employ nurses, but any affected member of the public could complain if the authority refused to accept a certain type or class of patient. That does not seem to us to be a very convincing way of looking at it. But
They could complain if it didn't employ any nurses.
Well, exactly. They could complain if they didn't employ
They've
nurses.
been breach with public law.
It's the concentration on what we say is a false distinction between private and public duties, which underpins the appellant's arguments in the present case. It is, in fact, a public duty to employ nurses, and a part of that public duty is to employ them satisfactorily. And insofar as their employment has been unsatisfactory because some of their work circumstances prove to be defective, doesn't make any difference to the public nature of the duty which the government is performing. Lord,
Is that a convenient moment, Mr.
it is a convenient moment, certainly, yes.
How much longer do you expect to be?
Well, I won't be as long as the 2 hours I put in for. I think I'll be another half hour, perhaps.
Very well. Well, we'll resume again then at 2 o'clock. Thank you very much. Court's now adjourned.